Welcome to Real Estate School. Today's topic, Leasehold Estates. A tenant's right to possess real estate for the term of the lease is called a leasehold estate, also known as less-than-freehold, which is ownership. The leasehold is held by the tenant or the lessee, and the property owner grants the lease and is known as the landlord or the lessor. The landlord conveys the right to occupy for a specified amount of time. The lease is considered personal property of the tenant. Just as there are several types of freehold estates, ownership, there are different kinds of leasehold estates. These estates are an estate for years, an estate from period to period, an estate at will, an estate at sufferance. So let's start with an estate for years. An estate for years, also known as a tenancy for years, is a leasehold estate that continues for a definite period. Even though it's called an estate for years, it doesn't have to be marked in years. The only important part is that it is for a fixed amount of time. That period may be years, months, weeks, or even days. An estate for years, sometimes called an estate for term, always has a specific starting and ending dates. The tenant is legally occupying the property during the period of the lease. When the estate expires, the lessee is required to vacate the premises and surrender possession to the lessor. No notice is required to terminate the estate for years because the lease agreement states a specific expiration date. When the date comes, the lease expires and the tenant's rights are extinguished. This type of agreement is great for landlords because they know when their tenants are leaving and can have a plan in place for a new tenant to move right in. If both parties agree, the lease for years may be terminated before the expiration date. Otherwise, neither party may terminate without showing that the lease agreement has been breached. Any extension of the tenancy requires that a new contract be negotiated. As is characteristic of all leases, a tenancy for years gives the lessee the right to occupy and use the leased property according to the terms and covenants contained in the lease agreement. A lessee has the right to use the premises for the entire lease term, and that right is unaffected by the original lessor's death or the sale of the property, unless the lease states otherwise. If the original lease provides for an option to renew, no further negotiation is required. The tenant merely exercises the option. Our next type of leasehold estate, an estate from period to period. An estate from period to period, also known as a periodic tenancy, is created when the landlord and the tenant enter into an agreement for an indefinite time. That is, the lease does not contain a specific expiration date like an estate for years does. Such a tenancy is created initially to run for a definite amount of time, for instance, month to month, week to week, or year to year, but the tenancy continues indefinitely until proper notice of termination is given. Rent is payable at definite intervals. A periodic tenancy is characterized by continuity because it's automatically renewable under the original terms of the agreement until one of the parties gives notice to terminate. In effect, the payment and acceptance of rent extend the lease for another period. Periodic tenancy is often used in residential leases. An example of a periodic tenancy would be a landlord and a tenant who is unsure how long the apartment will be needed have agreed that an apartment can be rented by the month without specifying the number of months the lease will run. The lease simply continues until either the landlord or the tenant gives proper notice to terminate. An estate from period to period also might be created when a tenant with an estate for years remains in possession or holds over after the lease term expires. If no new lease agreement has been made, a holdover tenancy is created. The landlord may evict the tenant or treat the holdover tenant as one who holds a periodic tenancy. The landlord's acceptance of rent usually is considered conclusive proof of acceptance of the periodic tenancy. The courts customarily rule that a tenant who holds over can do so for a term equal to the term of the original lease, provided the period is for 1 year or less. For example, a tenant with a lease for 6 months would be entitled to a new 6-month tenancy. But if the original lease were for 5 years, the holdover tenancy could not exceed 1 year. Some leases stipulate that in the absence of a renewal agreement, a tenant who holds over does so as a month-to-month tenant. To terminate a periodic estate, either the landlord or the tenant must give proper notice. Normally, the notice must be given at least 1 period in advance. For example, to terminate an estate from week to week, 1 week's notice is required. For an estate from year to year, however, the notice requirements vary from 2 months to 6 months. Many states have statutory notice requirements. The leasehold estates that we just talked about, an estate for years or a periodic tenancy, are 2 different ways leases can be formed between a landlord and a tenant. The next 2 leasehold estates we'll discuss are about what happens when the lease ends. An estate at will. An estate at will gives the tenant the right to possess the property with the landlord's consent for an unspecified or uncertain term. An estate at will is a tenancy of indefinite duration. It continues until it is terminated by either party giving proper notice. Basically, an estate at will means it can be ended at any time. No initial period of occupancy is specified, as in the case of a periodic tenancy. An estate at will is automatically terminated by the death of either the landlord or the tenant. That's different from our first 2 estates. It may be created by express agreement or by operation of law. During the existence of a tenancy at will, the tenant has all the rights and obligations of a lessor or lessee relationship, including the duty to pay rent at regular intervals. As a practical matter, tenancy at will is rarely used in written agreements and is viewed skeptically by the courts. They pretty much look at it as a month-to-month or periodic tenancy. Here is an example of an estate at will. A landlord tells a tenant that 2 months after the end of the tenant's lease, someone else will be moving into the apartment. The landlord gives the current tenant the option to continue to rent until the new tenant is ready to move in. If the tenant agrees, an estate at will is created. And then finally, an estate at sufferance. This is one a landlord would hope to never encounter. An easy way to remember this one is in an estate at sufferance, the landlord is basically suffering. An estate at sufferance arises when a tenant who lawfully took possession of the real property continues in possession of the premises without the landlord's consent after the right of possession has expired. This estate can arise when a tenant for years fails to surrender possession at the lease's expiration. In other words, a tenant refuses to leave when the lease is over and becomes a holdover tenant. An example of a tenant at sufferance situation could be when the tenant is unable to secure another place to live prior to the lease expiring. When a tenant fails to surrender possession or holds over, the tenant is responsible for the payment of rent at the existing terms and rate. A tenant at sufferance is not a trespasser. They are in legal possession of the premises. However, they do not have the right to stay. Legal action by the landlord is needed to pursue eviction. A lease may contain a holdover clause, in which case that provision will govern the rights of both the landlord and the tenant. Essentially, the holdover clause states that upon lease expiration, the rent goes from $1,000 a month to $5,000 a month. If the tenant signs that lease, the tenant would be obligated for the $5,000 a month. If the lease does not contain such a clause, then state law will govern and will typically offer 3 options for the landlord. The first option for the landlord can accept rent offered by the tenant, thereby creating a new tenancy under conditions of the original lease, a holdover tenancy. If the original lease term was greater than 1 year, generally the new tenancy is limited to 1 year. Option 2. The landlord can treat the tenant as a tenant at sufferance by either objecting to the tenant holding over or informing the tenant of such treatment, thus creating a month-to-month or periodic tenancy. The landlord receives rent and both parties have to provide notice within a certain period of terminating the arrangement. And finally, the third option for the landlord can treat the tenant as a trespasser and proceed with an eviction and damages action. Under this situation, the landlord must comply with the notice to quit requirements in the lease, as well as state law regarding the landlord-tenant relationship. Now, let's go over a few practice questions similar to what you may see on your state's licensing exam. Question 1. A tenancy in which the tenant continues in possession after the lease has expired without the landlord's permission is A. a tenancy for years, B. a periodic tenancy, C. a tenancy at will, or D. an estate at sufferance. The answer is D. an estate at sufferance. A tenant who remains in possession of the premises after an estate for years has expired is called a holdover tenant. If the landlord accepts rental payments, this action will usually create a periodic tenancy. However, a landlord can evict the holdover tenant and not accept any additional payments. Question 2. A tenant's tenancy for years will expire in 2 weeks. The tenant plans to move to a larger apartment across town when the current tenancy expires. In order to terminate this agreement, the tenant must A. give the landlord immediate notice, or the lease will automatically renew. B. give the landlord 1 week's prior notice, or the lease will automatically renew. C. do nothing, because the agreement will terminate automatically at the end of the current term. Or D. sign a lease for the new apartment, which will automatically terminate the existing lease. The answer is C. In common law, a tenant for a specified time period, one who holds a lease for years, does not have to give notice because the lease ends by contractual agreement, nor does the landlord have to give the tenant notice in such case. If the landlord or tenant wanted notice, that language would have to be included in the lease. Question 3. A lessee has a 1-year leasehold interest in a house. The lease automatically renews itself at the end of each year. The lessee's interest is referred to as a tenancy. A. for years. B. from period to period. C. at will. Or D. at sufferance. The answer is B. When a lease renews itself periodically, the arrangement is known as a leasehold from period to period, or periodic tenancy. Okay, our next question. A tenant's right to possess real estate for a definite period, with specific starting and ending dates is an estate for years, A. B. an estate at will, C. an estate at sufferance, or D. an estate from period to period. And the answer is A. an estate for years. When this leasehold interest expires, the lessee is required to vacate the premises and surrender possession to the lessor. No notice is necessary, as the lease agreement states a specific expiration date. State law may require notice of intent to terminate a residential lease. Okay, our next question. The death of either the landlord or the tenant will terminate the lease, and the parties' heirs will not be bound by its terms under which of the following tenancies? A. tenancy for years. B. periodic tenancy. C. tenancy at will. Or D. tenancy at sufferance. The answer is C. tenancy at will. The only lease that is terminated by death of either the landlord or the tenant is in a tenancy at will. A relationship at will continues only so long as both parties continue to mutually agree. If one party dies, a mutual agreement no longer exists. Our final question. If a tenant remains in possession of leased property after the expiration of the lease term without paying rent and without the landlord's consent, what is the tenant's status? A. Tenant at will. B. Trespasser. C. Periodic tenant. Or D. Freehold tenant. The answer here is B. Trespasser. The landlord can treat the tenant as a trespasser and proceed with eviction and a suit for damages. However, the landlord must comply with the notice to quit requirements. Well, that brings us to the end of our discussion on leasehold estates. Please like and subscribe, and let us know in the comment section if there's any real estate exam prep topic you'd like us to discuss in our upcoming videos. Thank you.